We already have 16 people. I'm sure there will be a few more joining us. So I will hand over immediately to Deepa, who was so nice to join us this afternoon and to have managed the session here on forced labor. I would say, Deepa, go ahead.
Okay, thank you, Carl. Pleasure again to be here. It's lovely and sunny outside in Geneva. I don't know about Turin. And nice to be with all of you. So I got a briefing from Carl about where you're coming from, mostly from ministries of employment, sometimes from ministries of labor, foreign affairs, and you're somewhat acquainted with the ILO's labor standards, or as they're known, also conventions. So I'm the head of the unit dealing with the child labor conventions, which Ben Smith spoke to you about last week, and forced labor conventions, indigenous and tribal peoples conventions, as well as the social security conventions. But the difference, of course, between the child labor and forced labor and the other conventions are that they are fundamental conventions. So the ILO conventions are divided into fundamentals, then governance, which concern labor inspection, tripartite consultations, and then the so-called technical conventions like the social security, occupational safety and health, maritime, all very important, but there is a certain hierarchy in the fundamentals, in that if member states are not able to ably ratify and implement them, it'll be much harder for them to implement the others. So let me do, Carl, I'm doing full screen, right? Yep. Okay. So just to, before going on to the conventions, so we call them conventions, not treaties, on forced labor, just to give you a snapshot view, according to the 2016 global estimates that the ILO produces, by the way, every year on forced labor and child labor, nearly 25 million people in 2016 were victims of forced labor. There are new statistics coming out on child labor in June this year and on forced labor at the end of this year. So this is, I'll come back to this later, but this is just to give you a snapshot view on the ground. So you see that there are two divisions. There's forced labor imposed by the state, that's 17%, and then you have forced labor imposed by private entities, and some of that is forced labor for sexual exploitation, and the rest is forced labor for labor exploitation. And the statistics speak for themselves. What is good about the ILO statistics, and especially on child labor, we've been doing them measuring this since 2000, and there's always been a drop in the number. So although there are still, for example, as Ben might have told you, 152 million children in child labor, compared to 2000, where there were so many more. So there has been some impact. The ILO, along with other UN agencies and the workers and employers organizations and the NGOs, have been able to have an impact in reducing child and forced labor. And just to give you a snapshot view also of the main sectors, and this I'll come back in detail if we have the time and you have the interest. You can see, so the sex industry, 4.8 million, and the private sector is 16 million, and you can see the sectors also, and the respective percentages, 24% were in the domestic sector, 18% in construction, 15% in manufacturing, 11% in agricultural fishing, and hotel and restaurant and trade, 10%. And if you look at it, there was a study done by the ILO on the profits, $150 billion a year. So that's a great incentive, right, for perpetrators of forced labor to continue their job. So we in the ILO have three main conventions. So you have all presumably heard about the ILO's conventions, which are very unique because unlike the UN or other bodies who adopt treaties, these conventions have to be adopted by government representatives, but employers and workers. So there has to be a consensus amongst the three groups, and the interests of the three groups do not naturally match the whole time. So they have to negotiate. And what we like to think of the ILO conventions is that the employers and workers bring the socioeconomic realities or their interests on the ground into the conventions. So that is the main difference. As you see, the Forced Labor Convention, which was adopted in 1930, quite old, it has 178 ratifications. We have 187 member states. It keeps increasing because the Pacific Islands keep joining us as members, but I think it's 187. The Abolition of Forced Labor Convention, which was adopted later, 176 ratification, and the new protocol to Convention 29, which fills certain implementation gaps because Convention 29 was adopted a long time ago. That has so far 49 ratifications, but I hear Luxembourg might send in its ratification. So it's an impressive number compared to other conventions. So ILO has been combating forced labor for more than 18 years. And Convention number 29 has been the overall framework which has been used, although it is old, to combat forced labor. And so it contains a definition of forced labor, and it contains an obligation for member states to suppress the use of forced labor in all its forms, including adopting legislation that criminalizes forced labor and provides for penal sanctions, as opposed to labor law sanctions, which can consist of fines. Penal sanctions means penalties of imprisonment, which are normally contained in the criminal code. So what is the definition of forced labor? And it's actually very simple. It's very broad. And it was developed even way back then as a broad definition so that it could capture different types of forced labor practices. So it is still valid today for some modern forms of forced labor, such as trafficking. So there are three elements: all work or service, which are exacted under the menace of a penalty, and for which the person has not offered himself or herself voluntarily, right? What does all kinds of work mean? Well, it means, irrespective of the industry or sector. Is it an informal relation? Is it an informal economy? Is it a formal relationship? Is it a migrant worker who has illegal migrant status? It doesn't matter. That is work or service that is covered by the convention. The menace of a penalty, well, it's not, it can be, if you don't do so much overtime, or if you don't do this, which is not in your contract, well, then, I might not renew your contract. That can be a penalty, but it might also involve the loss of a right or advantage. Well, if you do not do this, you might not get your promotion, or you might not go to university next year. And this is, I'm speaking more, the university thing is in the context of a country where the state imposed forced labor for students, university students, to pick cotton, to harvest cotton. We'll come back to that. So that's the third element. And the fourth element is voluntary consent. What is a voluntary? Does it mean that the person just says, okay, I'm willing to do this job right from the beginning? What happens though when the worker who agrees, for example, to a certain job, and then you have contract substitution? The job or the hours of work change subsequently. Well, then the consent is vitiated. It's not valid, and so you don't have free and informed consent. There should also, for the voluntary consent to be valid, there should be the possibility throughout the employment relationship for the worker to withdraw his or her consent, for the consent to be voluntary. I know this can appear complicated, but it's not. It's a very broad definition. And we'll see later on what it sort of covers, what sort of situations it covers, okay? So as I mentioned, so this definition is broad because, as I mentioned, it allows the ILO to combat traditional practices of forced labor, such as slavery, but also new forms of forced labor that emerged, in the 80s and 90s, such as trafficking, which is very well known, just not in the developing world, but also in developed countries, And as I mentioned, the definition not only covers forced labor imposed by private bodies, but also forced labor imposed by the state. to assist our constituents, the ILO has also developed indicators of forced labor. So for example, you know, I've engaged someone to work for me and I say to that person for 1 year, and I say, oh, unfortunately, you know, I can't pay you the first 2 months, but I'll pay you, I'll pay back when I get the money, you know. So that's sort of withholding of wages. It's a sort of a way to get the worker to stay on and to stay on. And in some countries, we've seen this retention of ID documents, excessive overtime. We've seen this especially very, very marked in the case of migrant workers in the Gulf states. And we're working with them closely to overcome this. Restriction of movement, deception. This is what I mean about contract substitution. You're offered something and then in fact, when you actually do the work, it's something different or the hours are different. And then physical and sexual violence. This is just to assist the constituents in identifying certain forced labor practices. Shall I continue, or are there any questions from any of you? Even if they're very broad, it doesn't matter, we can do it, or up to you. Any questions? No.
Yeah, Deepa, there was a question on the chat box, in the chat box by Mariana. So if you open the chat box, do you see it?
Hang on 1 second, chat. Yep.
Sure. Exactly.
Okay, how to analyze the imposition of a minimum, the right to strike? Sorry. So minimum service in sectors not essential to safety or health in the light of the prohibition. Yes, so the question.
Forced to work, yes, exactly.
Yes,
yeah.
Actually, it would be easier if people just talked and asked me the question, because, but in any case, the question reads how to analyze the imposition of a minimum service, limitation of the right to strike in sectors not essential to the safety or health in the light of the prohibition against forced labor. So if I understood correctly, is it okay to impose a minimum service in sectors that are not essential to safety and health? Sorry. Well, it's definitely not all right from the standpoint of the Freedom of Association Conventions. And from the standpoint of Convention 105, there is an explicit provision on the right to strike and the conditions under which the right to strike may be imposed. So often when we're examining how a minimum service is imposed, the supervisory bodies look at what they're saying under different conventions. So if it's not all right to impose it in sectors that are not essential to the safety or health of the population, whole or part of the population, then it's not all right under Convention number 105, but we haven't gotten there yet. So maybe let's get there and maybe we'll see. Okay. Okay, that's the only question I saw. Let's continue and then see if it. So there are two conventions. There's Convention number 29 and Convention number 105, which was adopted later. So there are 5 situations. These are 5 exceptions that do not constitute forced labor. Compulsory military service that can be that a member state can ask its citizens to carry out, provided that it's military service of a purely military nature. Now, if member states say, well, you know, you're conscripted, but then you start building bridges or dams like we knew they did in Myanmar, some time ago, that's no longer excluded. Normal civic obligations are an exception that do not constitute forced labor under the convention. For example, in some countries, the obligation to carry out jury duty, the obligation to help someone who's been in an accident, you don't run away, you know, so normal civic obligations. Prison labor. So if a person has been convicted under a court of law and has been convicted to penalties of imprisonment involving compulsory labor, and most countries in most parts of the world, prison labor is compulsory. That is not considered as forced labor, except when prison labor is carried out in private prisons, which it is done in a lot of countries, and I'll come back, in a lot of developed countries, surprisingly. I'll get back to that. So also work exacted in cases of emergency. So if there's a tornado, a hurricane, and the state calls on the citizens to assist it with dealing with this, then that is not also considered as forced labor. And then minor communal services, which are carried out in the interest of the community, those are not considered as forced labor practices, provided that the communities in question are consulted and they are minor. So they would not involve the building of a hospital, for example. Okay. So these are the exceptions that the tripartite constituents of the ILO thought to exclude from the definition of forced labor way back in 1930. Now, so this is a very simple convention. It has only 3 articles, but there were some transitional provisions. They are no longer applicable because they were applicable to the colonies. Those no longer exist. So Article 25 says that legislation must criminalize forced labor and provide for penal sanctions. Why? In order to be really dissuasive and to ensure that there are convictions. So as to prevent such practices from reoccurring. Why? Because, you know, and so we as the Secretariat for the ILO supervisory bodies, so we're a department filled with lawyers, we draft these comments based on the reports that member states send us and also employers and workers on how they are complying with the ratified conventions. And they say, oh, you know, we are enforcing the convention like nobody's business. You know, here, there's so many investigations, thousands, prosecutions, 500. And then you come to the convictions and there are 3 or 2. And then we're like, what happened? You know, that's not a deterrent. And then sometimes the penalties, we heard from, we had a report from a country recently, a trafficker who had 9 cases of trafficking against him. He was convicted to fines of to fines, and so the committee of experts said this is not enough. He was, you know, he had no prison sentences, so this is not considered a deterrent under the forced labor conventions. Penalties of simply fines. So basically, that's Convention 29. What has been its achievements? As I mentioned, there's been a significant reduction of forced labor imposed by the states. Is that just the ILO? No, I do believe that it's also the change in the political regimes of certain member states. We'll give you examples later. It's also the willingness of member states to embrace ILO technical assistance, to bring the provisions of national legislation and or practice into compliance with the convention. But there has been an increased awareness, and that's thanks to a lot of awareness raising sensitization activities, also done in collaboration with Turin, that has resulted in the adoption of legislative provisions that prohibit forced labor in nearly all countries. What are the challenges? Difficulty to identify, prosecute, and sanction practices of forced labor. And that's partly due to the reluctance of victims to come forward because they have to testify in order to bring the perpetrators to justice, even if they're promised protection, you see. The other thing is the challenge is the protection of victims. Member states do try, they have shelters, but then they put the children along with the adults, the women along with the men, and sometimes they bundle together different types of victims, which is not ideal. So there are issues there, but I think member states are sort of, have really improved since the convention was adopted. And if you look at practices today, they've gone a long way, but it's still a challenge. So most European countries have ratified or are going to ratify this protocol, which supplements Convention 29. So this was adopted in 2014. It has nearly 50 ratifications. And this is where it might be of interest to our audience today. It requires member states to take effective measures to prevent, protect, and remedy. Prevent the use of forced labor. including measures to support due diligence by the public and private sectors, so business, provide protection to victims, because this was seen as a gap in Convention 29. It does not specifically call for the protection of victims, and ensure access to appropriate remedies. It also calls on member states to develop a national policy or plan of action. And this was very much based on the experience of Convention number 182, which you have heard about from Ben Smith last week, where both Conventions 138 and 182 on child labor require member states not just to adopt legal provisions, but to adopt action plans and effective time-bound measures so as to have a holistic approach and not just to have a legalistic approach to very complicated issues. The protocol also asks member states to adopt specific measures against trafficking in persons, because that is what we see to be the most prevalent and modern form of forced labor. And then also to cooperate with each other in combating these worst forms, including through bilateral agreements or memorandum of understanding on trafficking, or it could be also poverty reduction strategy programs to poorer countries, help in education, in improving the education facilities of member states, etc., etc. The protocol, Convention 29 talks about deterrence. How do we get the perpetrators behind bars? The protocol also focuses on the victims. So as I mentioned, it talks about measures for their identification, release, and protection, and about access to compensation, which Convention 29 does not talk about. And this does not matter if the worker is legal or not in the national territory, and they should not be penalized for having been involved in illegal activities which they were compelled to commit because they were victims of forced labor. Okay, so that is basically the philosophy of the protocol. The Abolition of Forced Labor Convention, as you see, it was developed later in 1957. It does not revise Convention 29, but it supplements it. The definition of forced labor in 29 still applies, but this convention establishes a strict prohibition of recourse to any form of forced labor in just 5 specific circumstances. And these are the 5. So as a means of political coercion or education, or as a punishment for holding or expressing views. So why was this convention developed? It was developed when there was the onset of communism, you see. So for example, 1A, this concretely means, now for example, let's take a concrete case, an example in Myanmar. If people are protesting peacefully and they're peacefully expressing their dissenting views to the actual junta there, and then if they're peacefully protesting and they might not have followed all the procedures, and then they're thrown into jail, you might ask, well, how does that constitute forced labor? Well, because it is because of their opposing political views, they're thrown into jail, and then they're made to carry out prison labor. That is where the connection is to be made with forced labor. So you might ask the question, well, just suppose it is a country, and I can mention one, it's not a secret, Turkey, which has a lot of political opponents, but guess what? Prison labor is not compulsory there. So then anything that the social partners bring to the attention of the supervisory bodies, saying, well, this person was thrown into jail for his or her politically dissenting views. Well, it doesn't matter, we cannot deal with it because they're not required, these political opponents, to carry out prison labor. So there's no connection to there's a connection to the human rights, UN human rights conventions, but no connection to the forced labor convention. In the situation of, as a methods of mobilizing and using labor for purposes of economic development, does anyone have an idea of what that could entail? Can anyone just think of a member state that has used such labor for purposes of economic development? Carl, the other is
Anybody can give an example? It's one that is very, comes in the news once in a while. Huh? Anybody has an idea?
It's very interesting, and it's practiced, in some member states till today. It's getting rarer and rarer, but well, okay. I mean, this is supposed to be a training course, so I'm supposed to be giving the training. So we had a very interesting case in Uzbekistan, which is in Central Asia, close to Europe. And they had this practice just as the Russian Federation did, obliging persons to pick cotton, potatoes. And a lot of Russians thought in the good old days, this is normal. You know, I stop university, I stop my job and assist in picking. So Uzbekistan, the government used to oblige its citizens before children and also adults to pick cotton. I mean, it wasn't for a very long time, 6 weeks. So stop your studies, stop your activities. Nurses stop nurses and doctors stop going to the hospitals, come and help the government pick cotton, because they didn't have a fair recruitment system, voluntary recruitment system. And so that these people would be mobilized, they would pick cotton, they would have contracts sometimes, but the consent was vitiated because they didn't want to do it. They didn't want to leave their jobs. They didn't want, it's very hard. You are exposed to temperatures of 40 degrees. You're exposed to pesticides. And some people just didn't want to do it, you know. So the consent was vitiated. A lot of university students said, we don't want to do this. We want to. So they were made to pick that. And then the state would give them something, or really next to nothing. And then they would export the cotton. They were the 7th largest exporters of cotton. And I think they still are. And so this was brought to the attention of the ILO supervisory bodies. How? The International Organization of Employers and the International Trade Union Confederation submitted huge allegations of the forced mobilization for the economic development of Uzbekistan to the attention of the Committee of Experts, which I'm sure Karen Curtis talked to you about last week. You also perhaps Gita, which meets once every year. They're a body of 20 independent judges, professors of law. And so they assess this practice to be in gross violation of Convention 182 as concerns children, and then Convention number 105 as concerns adults. And so they express their deep concern. So they meet every December of every year, annually. These observations were picked up at the Tripartite Conference Committee of the International Labour Conference, which I'm sure you've been told about as well, which meets in June every year. So this was discussed in June 2010. And the social partners said, please accept. So they said, no way, we don't do this. Children are not just our present, they are our future. There's no way we would do that. So the social partners, the employers and workers said, well, please then avail yourself of ILO technical assistance or a direct contacts mission so they can assist you in ensuring full compliance. And yet, we don't need ILO technical assistance. So what happened? This went back to the Committee of Experts, which deplored the situation because there were more allegations. It went back to the Conference Committee. This happened 3 years in a row. And I think the government realized, I also personally went to the EU to talk to the Trade Committee, the Inter Committee, because they have a sort of, they had a sort of a textile agreement with Uzbekistan. So there was all that pressure. And I think in 2013, the government realized the only way out, because it's also, if you realize this is a forum where you have thousands of delegations and you're being hauled over the coals for egregious violations of basic human rights conventions. So they said, okay, we will accept ILO technical assistance. So with that, the ILO established a monitoring system with Uzbek monitors to detect cases of child or forced labor. At that time, it was still quite a non-democratic regime, but I think the government understood. It issued a decree saying, young persons under 18, stop, no more picking of cotton. With that, the ILO developed a decent work country program with the government. in March 2014, in that there were of course, there are other things like how to establish small and medium enterprises, build the capacity of employees and workers' organizations, how to establish social protection floors, but also how to eliminate child and forced labor. And that the government, we negotiated, they accepted. So, and with that, we have now a huge decent work country program in the country. We have a huge technical cooperation program that is funded by the World Bank. The World Bank has asked the ILO to monitor all of the World Bank's projects to make sure that there is no child or forced labor being carried out there. With the result now, and of course, 2 years ago, there was a change of government. The person who was the head of the unions at that time, she was very progressive. She's become deputy prime minister. So the change in the political landscape helps the ILO a lot too. So with all of that, the government has agreed to move to a free market system and voluntarily recruiting persons to pick cotton. And so they're still exporting cotton, but you know, the way it's supposed to be. So this is concretely what is meant and what is prohibited by the convention, using labor for purposes of economic development. Also as a means of labor discipline, you may have heard of seafarers who cannot abandon ships. But then in many countries, you have legislation which says, well, if they express disobedience or mutiny, they can be punished with penalties or imprisonment. That is in violation of the convention, unless there is a risk of health, there's a risk, sorry, to the health or safety of the ship or its crew. And then you have in D, persons cannot be punished for having peacefully participated in a strike. So this is, in fact, in Convention 87, the right to strike is not mentioned, but here, so if you have peacefully participated in a strike, even in an essential service, you cannot be thrown in jail and then asked to undertake prison labor. Then this is a violation of the convention. And the last is as a means of racial, social, national, or religious discrimination. Interestingly, this point has come up in countries, including the US, in terms of the disproportionate sentencing of certain minorities. And you may have seen that protests against that last year. So the disproportionate sentencing of certain minorities, ethnic minorities, and the meting out of harsher penalties. So by the way, the US has not ratified Convention number 29. It has ratified 105. And I guess most of you know why. But in case you don't, it's because they have recourse, wide recourse to the use of private prisons. So.
There was a question here.
Yes,
Irene, you can ask the question. I think that will be easier.
Yeah, please, because then I can take notes also. And it'd be nice to see you.
So you can also put the camera, Irene. Irene, you have to, we don't hear you very well. We see you, but we don't hear you.
I don't see her either. Maybe she's on mute.
Yeah, it doesn't work very well. So I think we have to, no problem, Irene. You can read the question then, Deepa. Yeah. That happens. It's fine.
Okay. Oh no, I'm going.
I can read it. Which measures would you recommend states to take to prevent the use of forced labor by private sector in their supply chains?
Yeah, that's very specific. I mean, I'd have to, can I answer that later?
Yeah, sure.
Okay. So let's, because I'm trying to, so these are just the global trends of forced labor identified by our committee of experts. This is just to give you a bit more, instead of the theory, a bit more of the practice. This I've talked about. So what are the different types of forced labor? A very modern form, trafficking in persons. As I mentioned earlier, the challenges are to identify victims who are often reluctant to come forward, and then the adequate prosecution and fight against impunity. You can also have the issue of complicit state officials who are corrupt, and the traffickers can buy off, you see. These are, I tried to put together different countries from different regions so as to be equitable. These are some examples of cases where traditionally there have been forced labor of migrant workers, Azerbaijan, but where there have been recently improvements also. We had a very interesting discussion with Poland, because this case was brought to the ILO supervisory bodies by Solidarność, where they said the government was allowing people from the Democratic People's Republic of Korea to be hired, and they were not being paid, or if most of their salary was being paid to the regime, and they were being surveyed. They had their own security guards, and then this was a big discussion at the conference committee, and finally, and the government denied that this was going on. And then, but what it said subsequently in its report is we're no longer issuing visas to these North Korean workers. Qatar, really a case of best practice in that region, although a long ways to go. There's been a comprehensive 3-year ILO technical cooperation program aimed at improving employment conditions and recruitment practices for migrant workers, and replacing the kafala system with a contractual employment system. Carl, should I talk about this at the end, the concrete example of Qatar, or should I talk about it now? What do you think?
Maybe we can proceed. I'm also looking at the time because we still have a few interesting slides, so I would propose we continue.
And so Thailand, all right, thank you. Thailand, where the ITUC brought huge allegations, and the ITF also, International Transport Workers Federation, of many seafarers and workers on fishing vessels from Myanmar, Cambodia, Laos, being subjected to forced labor practices on Thai fishing vessels. So Thailand took measures to establish multidisciplinary inspection teams and 24-hour assistance channels that are accessible to migrant workers in the different languages. There's been a slight improvement there. I mentioned that the convention was adopted a long time ago, and that was originally foreseen to combat traditional forms of forced labor, such as slavery. We don't hear about slavery much nowadays, do we? It still exists in Mauritania on a small scale, but we have a bridge project, a technical cooperation project, which is being implemented to assist the country to fight slavery. And what is the difference? Because before, the government denied that there was slavery. Now it accepts that there's slavery. It has accepted that a quantitative and qualitative study be undertaken to measure how many persons are victims of slavery, which is already part of a whole 50% of the problem solved, I would say, when there's acceptance of the problem. Then we move to, this is not progress, by the way. I mean, it's the issue of, you remember I mentioned how prison labor was not considered to be a form of forced labor unless it was a private prison labor. And then these are just two examples, Australia from two different continents. We see the same practices in Canada, the UK, Germany, New Zealand, and the US, which has not ratified Convention 29. And this is in violation of the convention, but the supervisory bodies are in an ongoing dialogue. Most of the governments say, well, this is very beneficial to the prisoners because we're teaching them new job skills so that when they come out of prison, they can re-enter the labor market, and that's great. And the supervisory body says that's great. And most prisoners, these governments say, want to work, which is true. You don't just want to languish in prison. The only thing the supervisory bodies are saying is, well, then make sure that if they want to, make sure that their free and informed consent is reflected in a contract. We just want them to accept that voluntarily, because if they don't, then it is in violation of the convention. There's forced labor, very unfortunately linked to armed conflict still, 2 different regions, but well known, DRC and Syria, where in Syria and Iraq, the supervisory bodies also brought up the issue of the sexual slavery, really sad, of both women and children. And this is again, Convention 105, the one that was adopted later, imposed as a result of expressing political views that are different. So in Benin, a small African country, the legislation was amended to decriminalize press offenses. The challenges remain in countries such as Azerbaijan, Cambodia, Thailand, Egypt, from different regions again, because there has been an increase in the criminal prosecutions by authorities in this country to suppress the peaceful expression of political views. And this is not a comprehensive list, of course. These are just a few examples. 2 examples, Angola and Bahrain, where the authorities allow prison sentences involving compulsory prison labor to be imposed on persons who peacefully participate in strikes, and then they go to jail. So these are, again, 2 examples from 2 different continents. This is in violation of Convention 105. Okay, I mentioned Uzbekistan, that's a case of progress. We're still working with Eritrea and Turkmenistan on the same issue. Eritrea, as many of you may know, compulsory work is exacted under national military service. That, of course, must be seen in the context of their previous wars with Ethiopia. They have a new peace deal. We've engaged with them. I went 3 times to Eritrea in 2018 and 19, managed to get them to commit to the ratification of Convention 182, which is already a great thing. We're trying to establish sort of not a decent work country program, but a technical cooperation project with them. Entry points would be, you know, occupational safety and health, labor inspection, and then we can move on to the other. The idea is to engage in dialogue and get them to comply in an instrumental manner. Turkmenistan, I was there also. We managed to get them to do some things, but they also are very, like Uzbekistan, still holding on to the practice of forced labor in cotton production. So that is likely going to be discussed in June this year at the conference. And just for your information, these are sectors, somebody talked earlier about the private economy. I thought, seeing the audience we had today, this could be of interest to you. So this is an estimated 16 million people who were victims of forced labor exploitation in the private economy. And you see the percentages. So domestic work, construction, manufacturing 15%, agriculture 11%, wholesale and trade 9%. And this is from the global estimates of modern slavery. Yeah.
Maybe here to Deepa, to yes, maybe see if there are any questions, because I'm also looking at the time, and since we are not putting the questions in the chat, maybe I can just ask here already if there are any specific further questions on child labor.
Hi.
I see Kelly. Hi, Kelly, please. Hi, good to see you. First time I see your face.
Thank you. Hi, Carl. Nice to meet you in person. And thank you very much for the presentation. It's very interesting and a great introduction for forced labor for me. I'm in Canada, and we have a strong interest in developing the care economy, unpaid and unpaid care economy. And so my question is regarding domestic work. Is this 24% including is it included in ILO's domestic work statistics of I don't know if it's 49.2 million people who are working under domestic work, or is this a separate statistic? Thanks.
So the domestic work is part of the, you remember at the beginning, I mentioned that the ILO had estimated that there were about 25 million people in forced labor, out of which 16 million are victims of forced labor imposed by the private economy. So that does not include state-imposed forced labor or forced labor exacted for sexual exploitation. So the 24% is part of the 16 million. It's a percentage of the 16 million who are victims. This domestic work, I don't know if that answers your question, constitutes the largest sector where persons are subjected to forced labor practices, according to the global estimates of 2017. And the next slide, Kelly. What are the issues? It's well, they're sometimes even excluded from protections in national labor laws. I don't think that's the case in Canada at all. But it's also the fragmented nature of recruitment. Sometimes they have to pay excessive recruitment fees. Contract substitution, sometimes they're told you're going to do this and then they end up doing something else when they come from another country. And then they're sometimes tied for a lengthy period of time to one employer by visa arrangement. So if the country has a certain visa policy that you can only have that one employer, and that is traditionally what the Gulf countries, the kafala system imposes on migrant domestic workers, you know. So if you want to change employers, it's not possible. You have to leave the country. And if you try to leave the employer, there are issues also. So I don't know if that answers you, or if you'd like to ask another question on that, I don't know.
No, that answers. Thank you very much.
Answers. Okay, all right. Thank you, Kelly.
Any other question that we can still that you want to ask at this moment? We still have 10 minutes, so I would say it's good to have your question now, so we can maybe the question Deepa from Irene. I'm just worried that we cannot deal with that question since we only have 10 minutes left. It's about maybe you can. Do you have any on this? What can the private sector do to prevent the use of forced labor? Of course, that's a very small question, but a big answer. Huh?
Yeah, they have to ensure this private sector has to make sure they have to ensure due diligence in making sure that there's no forced labor or child labor in their supply chains. As to the concrete measures, I will have to go back and see because it's different from country to country. I haven't really prepared for that. We do have a few measures that have been reported from. Because we only have received about 6 first reports on the protocol, so we don't have many indications of the types of measures the private sector is undertaking. But I can go back and
Oh, but it's actually, Irene asked, what would you recommend to states to ensure that the private sector does not use forced labor in their supply chain? So it's basically what does government has to do to...
Well, they have to make sure that the private sector is involved. For example, I would say when developing a national plan of action, we saw in 2 countries, I don't want to, the social partners had no clue as to what was going on. It was just a government-owned, and I think it's high time now, the government brought, because unions are sometimes involved in these discussions, but businesses are not. So when they're developing action plans, when they're developing policies to provide for protection for victims of forced labor, bring the social partners on the table, discuss with them, and see if you can develop an action plan that's realistic. Also encourage the private sector to do due diligence. When you're going to a country to make an investment, well, governments could say, well, have you made sure, I don't want to call it a rating or ranking of countries, but what are the child labor risk factors? What are the forced labor indicators? Remember the indicators I showed you earlier? So are these prevalent? Look at the comments of the supervisory bodies. If you want to, if you're an investor, so go to the government and say, has the private sector checked with the government? Has the government involved the private sector? And also, have you checked as to the forced labor, child labor risk factors in that country? And I think that is something ministries of labor are very familiar with, if ministries of, you know, I don't know, other ministries are not, maybe foreign affairs, but ministries of labor are quite familiar with, and they should involve the private sector more. And also, it might seem a bit mundane, look at the comments of the supervisory bodies. Because if the private, and a lot of the private sector, by the way, before I went to Eritrea, it was a Canadian mining company that came to us and said, well, you know, should we continue our investment there? Because we saw the supervisory body's comments, deep regret, concern on the issue of forced labor there. So we have feedback from you. So that's how engage with the wider international community also, you know. So I would say those are just general reflections, but look at the comments of the supervisory bodies, and at the end, I'll give you the link. It's very useful. It's country by country, convention by country, and especially on the Human Rights, the Child Forced Labor and Freedom Association, you'll see what the compliance gaps are, if any.
We have given to them last week a guide on how to navigate the ILO website, and amongst others also where to find information on NormLex, to find this kind of country-specific information also. Huh?
Yeah, it might not be the easiest of exercises for persons outside the ILO, I'm afraid.
That's why we created the guide for dummies, NormLex for dummies. So.
Okay. But once you get the hang of it, it's really, really useful, you know.
So we still have 5 minutes, huh? So I'll keep an eye out on the chat box. So I would say you can go to the conclusion. So maybe quickly go to some of the sector-specific slides.
Okay, construction is another area where 18% of forced labor cases have been identified. And as you see on the screen, there's a high level of industrial accidents and self-employment schemes that have contributed to coercive practices. Manufacturing, this could be something that our audience is more aware of. Small garment or footwear factories, electric and electronics industries. What are the concerns? Excessive working hours above what is allowed under the national legislation. Payment again of high recruitment fees. Again, illegal retention of IDs. And in some cases, physical violence. And we have heard this also in certain, you know, garment factories. I mean, I don't have to mention the countries. It's quite well documented. The other sectors, commercial agriculture and fishing. So I talked to you about the deep sea fishing vessels, because they are also well beyond the reach of national labor inspection systems. These persons are at a higher risk of various forced labor practices, such as the non-payment or late payment wages, restriction on physical movement, violence and threats. And in that case of Ireland, where there's progress being made, the reason it was an urgent case, there were also some deaths. So this is why it was, you know, sort of up as an Article 24 representation. It's a special procedure in the ILO. Bonded labor is more what can say the traditional form of forced labor, and found to be very prevalent in South Asian countries, especially Pakistan, Bangladesh, India. It can be seen in a range of sectors in the informal economy, such as mining and brick making, also carpet weaving. So that is another form. Now, this was to answer Kelly's question. She was a bit confused about the statistics. So you have the 16.9 million who are victims of privately imposed labor for forced labor purposes. You have an additional nearly 5 million persons, almost all female, who are victims of forced sexual exploitation. Why do I say forced sexual exploitation? Because under Convention 182 on the worst forms of child labor, young persons under the age of 18 cannot engage in commercial sexual exploitation. And there was a very interesting discussion with the Swiss government on this, because the Swiss government told the committee of experts, but no, our age of reference is 16, because in our country, children are allowed to engage in sexual activities freely from the age of 16. And so that's what we have put for prostitution. And the committee of experts said, sorry, but the right to engage in sexual activities must be distinguished from the right to engage in prostitution, which has a commercial component. You see, that is where the ILO conventions are different from. So the moment they are engaged in prostitution, it has to be prohibited from the age of 18. This was like a dialogue of the deaf for about, I think, 10 years. And then Switzerland changed its legislation, moved the age to 18, and the Committee of Experts noted that with satisfaction. What about persons over the age of 18? The ILO does not have anything to say. It doesn't say right, it doesn't say that it's wrong. If the country allows prostitution, then it has to be done in a way that, you know, respects working conditions, the normal employment contract. If it's forced, then that is in violation of the convention. Last, this is a state-imposed forced labor that I was telling you about, for example, Uzbekistan, Myanmar, abuse of conscription, etc. So there are an estimated 4 million people who are in state-imposed forced labor at any given point in time, bearing in mind that it was very difficult for our colleagues from fundamentals in the statistical department to get this accurate figure, because, you know, in most countries where there is state-imposed forced labor, access is not given to carry out surveys or the like. So thank you for listening. And that is, I guess, yes, Normlex, the site where you can find the information by country on the prevalence of you know, violations of forced labor, violations of child labor, etc., etc. I don't know how many of you have had the time to look at it. It's huge, and it's very user-friendly for me, but I'm in the ILO. I don't know if it's different for you, but thank you. So, Carla.
Thank you. Thank you very much, Deepa. And it's 4 p.m. I see, exactly on the dot.
Yes.
Huh?
Yes.
I had a quick question still on surrogate motherhood. I don't know if that rings a bell, huh? By Cyril. You can see the question here. It might be.
Hang on.
No, on while you are reading Deepa these questions, yes, there are some interesting tools that are available on forced labor, and also will upload them. Huh? In fact, Fundamentals has developed various tools. We have the IOE and ILO forced labor tool, I believe, huh? For business.
Okay. Yes. Which was developed with Multi, yeah.
Yeah. So that
enterprises.
is a tool. Exactly, that's what we have, and we also have this checkpoints application, huh? On forced labor, I believe.
Okay, I don't know about that one.
Yeah.
I know about the IOE tool, yeah, developed.
Exactly, huh?
Yeah.
So I will put that also online, so you can consult it. Again, on the ILO website, there's also the business network on forced labor, I believe. If it's, I don't know if it's called the business network, but there's a network, I believe, on forced labor.
For child labor, it's called the Child Labor Platform, and for forced labor, there is something. I don't remember the name.
Okay.
So everyone's thanking me. Thank you. I hope I wasn't too theoretical. I hope you understood it, and everyone's saying thank you. Okay.
Good.
Some questions on surrogate motherhood.
Yeah.
So we don't deal, for example, you know, and this is the thing, this has to be distinguished from, I'm sorry, Carl, if I sort of,
no, that's fine.
But so for example, under Convention 182, in the beginning, we had a lot of reports from governments on, oh yes, for sexual exploitation, we have so many children who are victims of incest. And we have so many children who are victims of abuse by the church, and we, you know, so sadly we're trying to tell people, you know, that is covered by the UN conventions on the rights of the child. We in the ILO and under our conventions can only examine the commercial sexual exploitation of children, i.e. the use, procuring, or offering of children for prostitution or pornography. So be it prostitution, even child sex tourism, but there has to be that component of work, you know. So surrogacy, I'm not sure Convention 29 would cover.
Okay, but indeed, I think maybe there's an issue of exploitation, but it's a very specific question. Thank you, Cyril, for the.
Yeah, thank you for the question. It's interesting. I'll go back to my colleagues and see, but I don't think this has ever been raised either by governments or by the social.
No, I know it's also a very ethical question in some debates in some country, but we do know that some women might face restriction on their freedom to act, including in their personal life, and they also might face poor treatment with the agencies, for example, refusing to pay them if they do not follow a very strict requirement. And also because surrogate provides, it's a service that requires dedication for a period of time, and it compromises the physical state somehow. So there are some questions behind, and I was just wondering if the ILO already addressed those questions or were already faced to these questions.
Yeah, not really. Thank you, Cyril. Very interesting question. No, it hasn't been brought up, but that's also, you know, and that's part of the job of the unions and or employers organization to do. Committee of experts can do so much. They're supervisory bodies. They base themselves on government reports. But then there is this alternative route for employers and workers to say, no, you know, actually the situation is not so rosy on the ground, and this is what is going on, like they did for spectrum. And then the experts can say, oh, so you government is saying you're complying with all these provisions, but in fact we hear that, and then of course, Cyril, this has to be backed up by numbers and figures and what regions, you know, there is this where women, so this is, initially they freely engage in a contract to bear a child or children, but then they are not paid or they're underpaid, they're confined, it's under the menace of a penalty, the consent. So they have to bring that to the attention, I would say the workers' organizations, to the forefront, you know, but this has not been dealt with by the ILO, but something to be looked at if it is brought to the attention of the supervisory bodies. You see, for a particular country. Let me tell you, for Poland, it was not Solidarność, by the way. It was a lady from an NGO who asked me for an interview in my office, and she said, we are an NGO that protects the interests of North Korean workers, and they are being subjected to all sorts of horrible treatment, and the regime is ensuring that they, how do you say, they pay 75% of their wages to the regime to further refine their nuclear arsenal, and they're living on in abysmal conditions. You know, there's nothing, because our constituents in the ILO are not NGOs, but they're workers and employers. So I said, I suggest you get in touch with the union and tell the union to submit an Article 23 observation. So governments say we are complying or not complying to an Article 22 of the ILO Constitution report. So workers and employers can submit Article 23s. And so this from this NGO submitted her allegations to Solidarność, who submitted to the Committee of Experts, and we were able to pick it up. It's a whole process, because Poland is not where the majority of North Korean workers are recruited or exploited. It's in countries like Russia and China, where the unions, I'm afraid, are not very independent. So, you know, so this is how it how the issues, you see. And there are some topics that everyone is willing to talk about and acknowledge, like trafficking. It's everyone experiences trafficking. It's horrible. It's got to be rid of. But there are more sensitive issues, like the state mobilizing its own citizens for forced labor, for economic development, like in Myanmar or Uzbekistan, or like Qatar with the kafala system. Very for them to acknowledge. So yes, it's an ongoing conversation. We believe that it's through an ongoing dialogue that we finally get countries to comply, and yeah.
Good.
have this
Good,
tripartite system. So yeah, okay, Carl. So thank you.
No,
So
thank
more
you very much.
questions. Yeah.
Yes, no, thank you very much. Yeah, that is the challenge always, to get it into 1 hour, such a complex topic of child labor.
I just added a few examples, Carl, just to
Mm,
sense of the realities.
good. So
Thank
for
you so
the rest,
much.
I'll release everybody else because we still have another session on Friday afternoon. So thanks a lot, Deepa, and thank you also everybody to be here for this hour on forced labor. So
Thank
have a
you.
nice
Bye.
afternoon. Bye, Deepa. Thanks
Bye.
again.
Bye, Carl. Bye, everyone. Thank you. Bye. Hope you
Bye.
enjoyed it.
Bye.